First case on our calendar is 05-853 and 959, State of Ohio versus Brian Haines. Mr. Friedman.
Good morning. I kindly ask to reserve 3 minutes this morning. Mr. Chief Justice, honorable justices, I am Ian Friedman here today on behalf of Brian Haines, along with co-counsel Ronald Fry. Good morning to counsel for appellee. On behalf of appellant Brian Haines, I respectfully move this honorable court to reverse the majority holding of the 11th District Court of Appeals, remanding this matter back to the trial court level for a new trial consistent with this court's order. This movement is based upon standing statute, legal precedent from this honorable court, as well as other appellate courts across the state of Ohio, the Ohio Rules of Evidence, as well as fundamental constitutional protections afforded the criminally accused. This honorable court visited battered woman syndrome for the first time in the early 1980s in the case of State versus Thomas. At that time, the court declined to allow testimony by an expert of battered woman's syndrome testimony because it had not been accepted scientifically within the scientific community. The matter was addressed again in 1990 in the matter of State versus Coss. And at that time, the third prong of denial from the Thomas court was overturned, and this court determined that the battered woman syndrome was now scientifically accepted within the community.
But didn't we, in Coss, limit it to a situation where self-defense was raised by the defendant, and it could only come in after that defense was raised? That's correct, Your Honor. It was limited. You're asking us to extend State versus Coss and have it, the battered woman syndrome be admitted in the prosecution's case in chief. Is that correct? No, Your Honor. And in fact, we're asking that costs remain the same. Okay. As this court was aware, and based upon its holdings, as this court just pointed out, the state legislature took House Bill 484 and codified that at the same time that cost was decided by this honorable court. It created revised code section 2901.06 subsection B, as well as revised code section 2945.392. The former was exactly in line with State versus Coss in that it allowed for expert testimony by a defendant when utilizing the affirmative defense of self-defense. The latter, 2945, allowed for introduction of expert testimony dealing with battered woman syndrome by a defendant who pled not guilty by reason of insanity. So it expanded on it somewhat more itself. But since then, courts across the land, courts across the state have allowed this type of testimony in accord with Coss and in accord with those two revised code statutes.
Mr. Friedman, could you help me understand? Reading the briefs and the Court of Appeals opinion, I'm still not clear on exactly when the testimony was offered here of the doctor.
I believe the testimony was offered in the state's case in chief after the purported victim had testified.
Not on cross-examination, is that right? Because there's conflicting wording in the Court of Appeals opinion. Okay. Your
Honor, correct. It was introduced after the victim's testimony. Now, if we are speaking of Dr. Eisenberg, there was also a Dr. Wassman that was introduced by the defense to kind of put out the fire somewhat. But Dr. Eisenberg was introduced after the victim and was subjected to cross-examination, and that may be where the confusion was.
And the defendant had, if I could just follow up, the defendant's counsel did not raise the issue of battered woman syndrome. Is that correct?
That is correct. It was the state that introduced battered woman syndrome.
Even the thought of battered woman syndrome.
It is correct. It was initiated with them. The defense's involvement with battered woman syndrome was reactive throughout the case. Correct.
Well, counsel, didn't the defendant's counsel try to discredit the victim's testimony by showing that she had the means and the ability to walk away from the relationship on cross-examination of the victim?
Yes, Your Honor, they did.
Would that not be characterized as opening the door for the battered women discussion, presentation to the jury on that evidence?
Respectfully, Your Honor, no, I don't think that it does. I think that defense counsel did what a defense lawyer is supposed to do, and that is test the credibility of the witness that's testifying. That's what they did in this case. I think that they certainly did not intend to, nor were they deserved of opening up the floodgates to what came thereafter.
Counsel, how are you to rehabilitate a witness when the defense says, you know, you never left, you always went back, you stayed in this relationship? How are they to explain to a jury to refute that testimony? Because we know battered women syndrome is a legitimate issue, and let's assume, just for the sake of argument, that there was a legitimate battered woman syndrome in this case. I know that that's an issue in dispute even, but let's assume there was in a case a genuine battered woman syndrome existing. Explain the woman going back. She's on the witness stand. Her credibility is attacked. You know, why you always went back, why you went back. How is that witness to be rehabilitated without bringing in that evidence?
I think that that witness, Your Honor, is able to be rehabilitated if they in fact can be rehabilitated. Again,
Sure.
We have to rely upon the facts and not simply an attempt to bolster credibility as was done here. The state then has their opportunity in rebuttal to rehabilitate, again, if so deserved.
But they cannot mention any psychological reasons that explain why a woman would return to an abusive relationship. That's your position.
Correct, Your Honor. And that is based upon case law in this state and statute in the state of Ohio.
Does that not, in fact, that does not present the full picture then to a jury, does it?
I think that the victim has the ability, Your Honor, to give the reasoning behind recantations or inconsistencies. So it's not as though they're completely foreclosed on offering explanation.
And isn't the purpose of expert testimony to explain what the common person cannot understand? I mean, most common healthy relationships have a hard time understanding why someone returns to abusive relationship.
The purpose of expert testimony, you're correct, is to aid the trier of fact and assist them in their determination. Correct. I will jump ahead in my argument to say, however, in this case it went far beyond that. Here it was provided to bolster the credibility of the victim in the case with specific reference to fact, time, and name.
You wouldn't have had any objection if this testimony would have been brought up in rebuttal after the defense put on his case, if he put